Welcome to the Dirty Verdict Podcast. We're your hosts, trial lawyer Kyle Herbert and mediator Peter Taaffe, break down Texas legal news, lawsuits, and verdicts. And now, here's Kyle and Pete.
All right, welcome back to another edition of the Dirty Verdict with your host, renowned trial lawyer Kyle Herbert, and modest mediator Peter Taaffe.
Welcome back, everybody. We have got two special guests with us today. Brad Wyly and Kelly Cook of the law firm of Wyly Cook right here in Houston, Texas. Unfortunately, the Dirty Verdict does not have the budget for 4 microphones. So Brad and Kelly will be sharing one, which is fine because prior to being trial attorneys, they had a renowned lounge act, also with a very low budget, where they shared one microphone stand and one guitar. Was it banjo? It may be a banjo. In any event, guys, welcome. Tell us a little bit about yourselves. What do you do? Where do you live? Tell us all about you in 30 seconds or less.
Yeah, my name's Brad Wyly, and I live in Houston, born and raised in Galveston, and have my own firm here doing primarily personal injury work. And I also teach at UH Law School.
What do you teach?
I teach pretrial litigation. I'm an adjunct professor there.
Awesome.
Kelly Cook, grew up in West Virginia, moved to Houston in 2007, practiced with Brad here doing primarily personal injury, Fair Labor Standards Act, and plaintiff side appeals, doing appeals on a contingency fee basis.
How long you guys had a law firm together?
Since 2013.
Wow, that's 10 years.
Yeah, March, I think, 10 years. We got to do something big.
Fantastic. All right, we've got a few cases that have piqued our interest. You guys jump in. We'd love to hear your take on them. Peter, what you got for us?
All right, first one, Kyle, is a recent settlement. The byline is naked man shot in hospital by Houston cops gets $900,000 settlement.
Before we go into this, I want to make sure nobody has like a vested interest in the nude litigation industry. You guys have never been shot nude or shot anyone nude or litigated on behalf of nude parties. Is that fair?
I have litigated on behalf of many nude dancers. The exotic dancer docket is a significant Fair Labor Standards Act docket, and I've had several of those cases. So I do represent the nude community.
A historically underrepresented demographic. And so, Kelly, thank you for your service to the nude. Brad?
I have not had any people in my car wreck cases. They've all had their clothes on.
Well, disappointing as that is, let's move forward. So this is a case, who's the plaintiff, who's the defendant, Peter?
The plaintiff is a man named Alan P-E-A-N, Peen.
Okay.
Peen. Yes, and the defendant, the settling defendant, is City of Houston. But according to the story, he still has pending claims against the hospital where he was shot and maybe some of the medical providers there. So the story was this: in August of 2015, this gentleman got in a minor car accident. He went to Houston's St. Joseph Medical Center. He had a history of bipolar disorder. He was seeking help for acute emotional distress. But ultimately, he found himself nude in the hospital, and he was shot by Houston police officers. So this is 2015. The case was filed in 2016. And then just recently, in the later part of 2022, the city settled for $902,500.
And the injury was he got shot multiple times by HPD. Is that right?
That was the allegation in the case.
So, interestingly enough, I've been following this case with some interest. I on occasion have represented folks against police departments and sheriff's offices for injuries like this. They are incredibly hard to prove. Have you guys ever had a case like that?
Yep, I have. I represented an individual that was shot, I believe it was 6 times in the back and 1 in the front. Against HPD by an off-duty police officer. And that was an extraordinarily difficult case because of, under this 1983, you have to have, this ratification or a policy or plan. And at the time of our case, they had not yet reached the point where they said, listen, HPD is so ill-managed that they effectively have a policy of allowing police officers to kill people.
So 1983, that's the federal law that says what?
Deprivation of civil rights under color of state law. That's when a state law government actor deprives one of your civil rights. In the shooting cases, it's your Fourth Amendment right to be free from unreasonable seizure, such as being shot 6 times in the back.
That seems like a good law to me. So did you get your case resolved, or was it confidential, or are you allowed to talk about it?
As far as so I actually left the firm that is handling that case. My understanding is the city was ultimately dismissed, and then their action proceeded against the officer. I'm not 100% sure how it finally resolved, but we were not able to meet this ratification or policy or procedure element, and so the city was excused. I believe actually the Fifth Circuit signed off on the city being excused.
So in a case like that, you got to prove not just that a police officer did a bad thing, but a police officer did a bad thing, and it is the police department's policy or procedure to allow those bad things to essentially happen.
Right. There is a policy that will expectedly give rise to a deprivation of one of your constitutional rights.
So I followed this case with some interest, like I said, and I'm going to give you a little bit of the facts as I understand them. And again, this is coming from what I can cull from the pleadings and the information available in the media. So this gentleman had a pre-existing mental disorder that he was aware of and had been managing. And he was in a pretty minor car wreck, got himself to the hospital, and immediately told them, I've got these mental problems and I'm worried I'm about to freak out. And made a pretty honest and accurate reporting of what was wrong with him. And then essentially what he said was going to happen is exactly what happened. He took off his clothes. He started acting, for lack of a better word, like a crazy person. And rather than try and, I guess, intervene medically or in whatever way that's, probably appropriate, some intervention less than getting shot, hospital called HPD. HPD showed up and put a couple of bullet holes in this guy. That said, it's kind of crazy to think that after all that, and after all those years, we are all, and tell me if I'm wrong, I'm impressed with the $900,000 settlement. That seems like a great result for Mr. Peen and his attorney, Mr. Malugin. Do you guys think that's accurate?
I agree. I said these 1983 cases are extraordinarily difficult claims, among the most difficult claims I've seen as a plaintiff's personal injury attorney. And so a high six-figure settlement in a situation where everyone is going to understand an officer responding to a crazy person who is naked, that officer is in some degree of danger.
Sure.
And so that is one of the things where these cases become very difficult is we want officers to be able to use reasonable force. But when they go beyond reasonable force is where we have to draw the line, and proving that is very difficult.
Well, kudos to Mr. Malugin, and sorry for his client. But sounds like he's getting at least some measure of justice. But Peter, this case isn't over. Is that fair?
That's right. According to the news, he still has pending claims against the hospital, I think the security company, and some of the medical providers. So I'm not sure what the procedural status of those claims, if they're still stuck in, they'd be stuck in federal court just because of the claim against the city would be in federal court. We'll have to look it up. Maybe Joe would like to come on sometime and give us a...
We probably give Joe a call, see if he's around. I'm wondering if the defense has argued that letting your patient get shot with a couple of bullets is part of your medical standard and is going to be subject to immunity or at least caps. And my guess is they probably have. Are you able to tell from the pleadings?
No, well, we'll look that up and we'll report back on the next one.
Excellent. Interesting insight, guys.
All right, Kyle, next story. This is a sports story, but also a law story. So background facts are this. December 12th, 2022, news reports came out that University of Texas head basketball coach Chris Beard had been arrested and accused of strangling his fiancée at their home. Texas suspended Coach Beard following the arrest. The fiancée Randy True recanted her accusation shortly thereafter. The school apparently did an investigation and then relatively recently made the final decision that Mr. Beard would be terminated, or his contract would be terminated for cause, as we know that has legal significance, and that he would no longer be the coach at the University of Texas. So the legal part comes in. Does Chris Beard have a cause of action against the University of Texas? And if so, what will happen to it? Thoughts?
I feel like as a Texas Longhorn and a moderately interested basketball fan, I have to recuse myself here because this basketball program is cursed and it's infuriating and it makes me very sad.
All right. Well, I will just respond to that by noting that under interim coach Rodney Terry, they are undefeated.
All right, I'm back in. I am going to invoke the Texas Tech Red Raiders versus Mike Leach lawsuit, wherein you can fire a dude for cause, but it doesn't matter because if you're a state institution, you do not have to live up to your contracts. And, at the end of the day, whether you believe this young lady's first story or her second story or his first story or what the police said, it's all very unsavory, and I don't think it probably moves the ball forward for the University of Texas or Mr. Beard. My guess is Coach Beard will coach again. It will not be at the University of Texas. I'd be surprised if Coach Beard filed a lawsuit. I'd also be surprised if the University of Texas didn't pay him some money to move on down the road. And congrats to Coach Terry on being 7-1. I believe we've got a tip-off in about 2 hours here, so we're going to have to wrap this up. Brad, any closing thoughts on the University of Texas at Austin versus Coach Beard at all?
Yeah, I think I agree with you. My first instinct, without having done the research, obviously, but my gut tells me that it's probably going to get resolved, hopefully out of court, and everybody's going to go their separate ways. There's going to be some sort of settlement. We probably will not know what the number is. Chris Beard will find a landing spot somewhere because, he's a hell of a coach. And it's an unfortunate situation because my understanding is it was his dream job to be back at the University of Texas. I mean, he did incredible things at Texas Tech. I think he was on his way to doing incredible things at Texas. And hopefully this new coach will keep us on the right track and everything will work out and everybody will be fine.
I would say this. I wasn't there that night. None of us were. I don't know the full story. If he did put his hands on this lady, he deserves to have the book thrown at him. But boy, there are so many different stories coming out of that it's. I don't have a dog in the fight. It mostly just makes me sad for Coach Beard and his family and this young lady. But that said, Craig James remains undefeated against Texas Tech when it comes to getting their best coach of all time fired. And unfortunately, the dearly departed Mike Leach, who I will still say is my favorite college football coach of all time, he still has a big zero in his account. And that Texas Tech is going to put some funny stickers on their helmets, but will refuse to pay Coach Leach's widow or his estate. And so get your guns up.
Rest in peace, Mike Leach. And what is Craig James doing these days?
Craig James, I think he's still being oppressed for his religious beliefs. But that's between him and the Lord.
All right, we'll keep an eye on that one and we'll report back.
Very good.
All right, guys, next one, moving to the world of music. Harris County District Court, rapper Megan Pete, known better as Megan Thee Stallion, has sued her record label, one of them, 1501 Certified Entertainment. A lawsuit was filed earlier, about this time last year. The issue is this. She was apparently contractually obligated to provide an album to the recording or the record label. There was a compilation called Something for the Hotties.
You keep emphasizing the. Why is that?
Because it's spelled Thee. So I don't know if you're supposed to enunciate the.
Is that like ye old kolache shopapy?
I think so. Yeah. Anyhow, that's the question. This is the legal issue being argued. So the company says, look, that's not an album. It was a bunch of stuff and it didn't qualify as an album.
This album, they're out there judging Megan Thee Stallion's art.
Yes.
Well, that seems unenlightened.
So the record company moved for summary judgment, asking the judge to declare as a matter of law that whatever Miss Pete provided qualified as a quote-unquote album. And from reading the pleadings, there were many references to the dictionary, things such as that, to define what albums are. So it's going to be an interesting, first of all, in 2023, is there an album? I mean, what is it? There's not a record, like a CD doesn't come out with like 15 tracks on it.
It's all TikToks these days, as I understand it.
Yeah. So,
or the
no,
TikToks.
I mean, that's really the issue, is she put out a bunch of things that our kids would say, yeah, that's how music is distributed now. Whereas if you're looking at it from 1980s, what's an album? And there's a gold record up on your wall. So that's where it meets the road. Well, the presiding judge said, because as we know, there's ambiguity is typically something that judges will kick to a jury to decide.
Sure.
And which is apparently what this court did. So
to the jury
will decide as early as June of 2023 whether this is an album or not.
Who's the judge?
Judge is Judge Schaefer.
Excellent judge.
Excellent judge. And as we know, courts are relatively backed up, but this may be one that the judge may exercise his discretion to move to the front because it's rather interesting.
Well, let me ask this. What's the name of the album?
Something for the Hotties.
Well, we happen to have a couple of guests here who, for our purposes today, are the Hotties. Kelly, you know a little bit about Megan Thee Stallion and her art. Tell us what you think about this.
I think it is a dirty lie that I know anything about Megan Thee Stallion. So I am far too old, unfortunately. What I know about Megan Thee Stallion is that she had a small role on the She-Hulk show. So I was going to find out, is the She-Hulk representing her in this case, as she did on the TV show?
Is She-Hulk, is that a show or is that a person?
It is a show about a lawyer who turns into a giant green monster because she's cousins with Bruce Banner.
The Peter Taaffe life story.
No. Apparently, I'm looking at the docket now. The She-Hulk has not made an appearance yet.
She-Hulk?
Yeah, She-Hulk.
I'm sorry.
Kyle, you need to talk to your daughter.
I've got these hairy old man ears, and it's hard for me to...
It is also interesting to me. I mean, do we want courts deciding what an album is? I mean, do we want to, if she contractually agreed to produce, a rock opera, we could perhaps say this is or isn't an example of that form. But an album is the 4 minutes and 33 seconds. Is that a song?
So I actually have a very little bit of experience in this. A long time ago, my firm represented a local rapper in a federal case. His name was Lil Flip. And we got into a breach of contract case and about a lot of stuff like this. But we were in federal court. And it was like the world turned upside down to try and communicate what different hip-hop terms meant. And I am so nerdy, but it was actually kind of entertaining to translate, this weird contractual entertainment contract language to sort of hip-hop culture, to what an actual judge can understand, who at the time that I handled that case, I was the youngest guy in the courtroom probably by 20 years. And well, good luck to Judge Schaefer, I guess.
Who was your judge in federal court?
I believe it was the Honorable Keith Ellison, but don't catch me lying, because this was, 2006 or 2007. But I do remember him asking me who we represented, or asking my co-counsel, and we talked about, is it Mr. Flip? Is his first name Lil? Is it Lil the Flip? And I was like, let's just use his Christian name, which is Wesley Weston. And he was a great client, by the way. And my recollection is we won that case, and he ended up, winning on all accounts. But it's interesting to watch the courts kind of grapple with this cutting edge entertainment stuff.
Well, there'll be a decision one way or the other, unless of course there's a settlement. But it will be something we'll be watching and we'll report back.
That said, Megan, if you're listening, the Dirty Verdict would love to have Megan the Stallion and the Peter Taaffe and the Kyle Herbert you're always welcome on the Dirty Verdict.
You got that right. All right, guys. Next topic is could be the start of something really big or could be a complete bust. The headline is Seattle Public Schools lawsuit against media giants like TikTok, Instagram, and Facebook faces uncertain legal road. And the short background is just a few weeks ago, the Seattle, one of their school districts, and there's been a second school district that has sued the major social media companies, YouTube, Facebook, or Meta, Google/YouTube, basically saying that they have, through their algorithms, et cetera, have created a bunch of zombies of our children to where they are addicted and cannot get off this, and it is causing incredible mental strain, mental health issues that these schools are having to pay. So I assume it is similar to some of the tobacco lawsuits that were filed by some of like the health districts here in Houston when everyone was on the tobacco program, saying we've got all these additional costs we've incurred to treat people and you're on the hook for it. Apparently there's a case in front of the U.S. Supreme Court that's supposed to hear arguments next month that will involve whether the social media companies enjoy some type of, not necessarily immunity, but a preemption argument. The argument obviously in preemption is Congress has kind of dictated that they're going to be overseen by some type of administrative scheme, and therefore the courts are not the regulators that the plaintiffs obviously are wanting them to be. So, Kyle, my kids are much older, and
well, that's what I was going to say, Peter. You've got 4 kids, and I think I've met most of them.
Oh, they're all full on addicted. But
weren't they zombies though before you gave them the internet?
They were. Well, mine were at the age where we were struggling with the age that they should get the phone. So it was 4th grade, 5th grade. Now, of course, kids get them like as soon as they can hold an object in their hand, they get the phone. So we kind of miss that. Mine obviously post a lot, but they're about, I would say they're kind of adults now. So they miss that. But you tell me, your kids are more right in the sweet spot of what I think this lawsuit is intending to address.
All right, so I got a couple ideas and a couple of questions. You guys all chime in here whenever you get a bright idea. So I guess they're alleging that the social media platforms engineer their interface in such a way that it, stimulates the brain such a way that you can't turn away, you're addicted, you can't focus, you can't read, you can't study. Is that basically it?
And then I think associated with that, some of the mental health issues with, bullying or body image shaming or fear of missing out, being left out, all the kind of stuff that comes with it. So, and there's really kind of 2 components. One, I think probably a lot of people have seen The Social Dilemma, which talks about how they kind of push people to take one position, or there's a battle, obviously, to positions. But then this one seems to be more about just the rote addiction to looking at it all the time, the dopamine hit that you get from some type of positive feedback or whatever that you're anticipating, which causes an addiction, much like opioids or cigarettes or what have you.
So I've got one question that I think is minor, and then kind of a broader idea. The small question is, is it just a couple of local school districts?
At this point, there is the Seattle, which I assume is a large one, and then another.
Aren't these kids all addicted to coffee already, all hopped up on the Starbucks?
Could be. I mean, yeah, it's that's the thing. I mean, it rains there all the time. What else are you gonna do?
Right. Just inside and play with your TikToks.
Yep. So we're on the front end. Like I said, this could be, as we know, tobacco cases turned out pretty well for the lawyers that did them. Opioid, I think.
So, I mean, I 100% agree with the basic idea. And there's no doubt in my mind that these platforms are engineering their product in such a way that their marketing is perfect and that it sucks you in and you lose hours and hours doing it. I know that Casinos did that without the benefit of drugs. They give you the right lighting and the right music and the right flashing lights, and you basically are a raccoon and you can't help but reach out and keep pulling the lever. I have no doubt that exists. It's interesting that it seems like we're like on the edge of this revolution. Like, we didn't have laws to dictate how the Industrial Revolution would regulate labor, right? The problem existed, and then we had to go back and fix it. And we're kind of the same way with technology, right? Like, it's kind of out there running amok with very little oversight until you see every now and again, right? We have these congressional hearings where somebody gets Mark Zuckerberg and says, "Sir, will you please tell me what an email is?" Which is completely toothless and a waste of time. I'm curious if these folks have any recourse. I'm suspicious that a school board has much standing. I guess they're going to argue that they have to pay for more school counselors, or
That's exactly what they're arguing.
Is that right?
They've incurred additional costs associated with drafting of special lesson plans, adding mental health type counselors. Let's see, there's some other increased costs.
Now, Brad, your guidance counselor sat down with you and at some point told you not to smoke cigarettes and drink so much RC Cola down in Galveston.
Years ago.
Many, many years ago. What's your take on this? What do you think?
Yeah, so a couple of things. You mentioned the casinos, and that worked very well on my parents. They were every other weekend at the casino, so there's definitely truth to that. I'll say with respect to this, I think from at least what I've heard in regard to Facebook, which is now Meta, they own Instagram. And I don't know if y'all remember this, but the whistleblower came out, it's probably been a year, and talked about how Facebook had done these internal studies, and they knew that Instagram in particular was harming young girls, giving them body images. So I could see there being some liability with respect to Meta. Now, who ends up being the proper plaintiff? Is that the school board? Is that the parents? Is that somebody else? Or the child itself who pursues that? I don't know. But I would be interested to see what other evidence comes up with respect to some of these other platforms like TikTok, et cetera. But it seemed like what I heard from Facebook, there's something there.
So the other interesting parallel, as Peter pointed out, to the tobacco industry is that it always seems like it's the internal documents that bring down the house of cards, right? Like Brad and Kelly and probably Peter to a certain extent grew up kind of in the shadow of a bunch of Texas tobacco lawyers who are the guys that went through the millions of documents where where the major tobacco companies had told foreign governments, like, don't worry about your high incidence of difficult births. If we give all women cigarettes, infant mortality will increase, but costs to deliver babies will decrease because the infant weight will be smaller. And all of these terrible internal studies. So I guess the moral of the story is, if you're running a giant billion-dollar company, when they come in the morning, they're like, "I'm here to do an internal study," you just fire those people.
Yeah.
You run your business with no internal controls or studies. But I mean, that's the tobacco is kind of the most interesting parallel that I see.
Well, and don't forget asbestos. I mean, same kind of thing. I mean, they were for years covering up. They knew back in the 20s or even before that asbestos was highly toxic and caused cancer and other things. And they buried that for a long time.
Well, if anybody deposes Zuckerberg, I suppose I'd like to be there. That sounds pretty interesting.
From the movie The Social Network, you remember that movie?
Yeah.
He was not a very good witness.
I think whatever squirrels program the robot in his head to say, that's really the source of the best information, because that dude looks like a total weird outer space robot.
Well,
no offense to outer space robots.
It is strange that we've reached the uncanny valley with somebody who appears to be human. By all accounts, he was born on this earth of a woman, and yet strangely he is deeply in the uncanny valley where it's like it looks human, but also not.
So maybe he won't be Meta's key witness in the litigation that will likely ensue.
The law firm that's filed it is called Keller and Rohrbach, Rohrback. They've got offices, I believe, obviously in Seattle and some other places. A copy of the complaint can be found on their website, and we'll endeavor to post it on ours, a link to it. It is 90 pages long. It is fascinating. I would recommend it to anyone with kids, as far as they do obviously they're advocates and they're advocating a position, but there are a lot of citations to kind of what they're saying about what the social media companies are doing. So
what's the website address?
It's just Keller Rohrbach, so KellerRohrbak.com. So I'm going to read it again. It's very detailed and extremely interesting.
And in the event we want the universe to implode on itself, Mr. Zuckerberg, if you and Megan the Stallion want to come on together, we will accommodate you, and we'd love to see you. And as always, you have a warm and open invitation.
All right, next one, we're going to hit two lawsuits real quick. Recent ones filed in Houston. The first one is a Jones Act seaman, or the estate and the personal representative and the family suing Orion Marine Construction, which is a dredging contractor, but generally their employees, most of them are qualified as Jones Act seamen. So in this complaint, they contend that the seamen contracted COVID in December of 21 and been exposed and got it from his colleagues, but was not provided any kind of medical care until he was at the point of no return. At that point, he finally got treatment, but he ultimately died from COVID, according to the petition. So this brings up an interesting issue, Kyle. I think maybe we actually probably first met when I was a plaintiff's lawyer doing maritime work, and you were a defense lawyer doing maritime work.
How the world has changed.
It has.
Yeah, I think that's correct.
And as you know, well, you can expound on this. The concept of maintenance and cure, what does that mean?
That's a great question, Peter, and rarely do I get to expound on this topic. So maritime law goes back all the way to Roman law. And under Roman law, if you were working on a boat, working offshore, manning the oars of the trireme, and you were out on a vessel in furtherance of the master's job, and they had a duty to bring you back to port and to take care of you medically for anything that you suffered while you were out on the ocean. And that law has stayed consistent, made it into a British law, made it into our common law, and it's still the law in the state of Texas under what we call the Jones Act, well, federal law, which applies to Texas, the Jones Act. And basically what that says is if you get hurt while you are offshore or qualifying as a Jones Act seaman and you're not offshore.
In the service of a vessel.
In the service of a vessel, and almost anything is a vessel, that your employer or your master has to take care of you if you get hurt or you get sick. Brad knows this. He grew up on Galveston. He's basically, he's been a riverboat captain almost his entire life. But it's interesting. They're not suing, I guess, because he contracted COVID, which leads to all sorts of statistical, epidemiological arguments as to how did he likely get sick. They're saying he got sick and you weren't able to provide a reasonable amount of care such that he didn't die. I mean, is that right?
That's right. It is specifically that their failure to provide timely medical care causes death from COVID. So a couple things. One, if you look at the jury charge on this, there is a damage for how the delay in treatment may have aggravated or caused you to sustain additional injuries. This was an interesting case. Did y'all ever hear about this case, a spider bite case that actually Sean was involved in it, where a seaman got bit by a spider on a boat, and there are spiders everywhere. And he ultimately got MRSA from total lack of treatment, and then died of cancer. So they got a huge verdict. I think your old firm was on the other side of it. We're not going to mention any names, or which old firm we're talking about. But in any event, there's a huge verdict, And people say, oh my gosh, it was a spider bite. But it was failure to treat, which ultimately led to him contracting cancer and dying. And
So what is the connection between the MRSA and the cancer?
there are, I guess, apparently there are studies that link those two, or at least there was a doctor who was willing to testify under oath to say it.
I would say this: if you want to find wacky verdicts, look no further than maritime law, because the law, if you think about it, you're going offshore, you're completely at the mercy of your employer, right? Like whether or not you ever see your family again is completely tied to the goodwill of your employer, and the law recognizes that. And so you see all kinds of weird, convoluted fact patterns because the courts want to make sure, first of all, our maritime industry is hugely important. And so the courts want to protect seamen, sailors, and make sure that they're taken care of. And so you see these weird fact patterns where you've got spider bites, or you've got the person that cut their hand open because they had failed to stock ice cream scoops, and somebody accidentally cut themselves with a knife and cut off a finger, and that made a ship unseaworthy. And so maritime law is fascinating and entertaining and funny. On the other side of this, I've had a couple of cases that involve MRSA. Whoa, you don't want to get that. Methicillin-resistant Staph aureus is a horrible thing to have happen to you. But bring it back to this COVID case. Is this pending here in the Southern District of Texas?
It's actually pending in state court because, under Jones Act, they don't have to worry about diversity.
Right.
I believe this company, Orion, is based in Texas anyway, but should be non-removable because it's a Jones Act case. One other takeaway, and we can move on to the next one, is, you alluded to this, is vessel. The definition of vessel is very broad, and a lot of people don't realize that they are covered under the Jones Act, which is usually deemed to provide a better relief to an injured worker than the workers' comp system in Texas. So it's something, if you're a lawyer who's got a case and you think it may be comp, and therefore you're not interested in it, you may want to double check or talk to some maritime lawyers to make sure.
I'm happy to field those calls.
Well, if you know the answer to this question, I would like to know if proceeding under maritime law is a superior remedy. Is it not the case that if I go to court and the flag has a gold fringe, that we are proceeding under maritime jurisdiction and my client should be entitled to the full protection of the Jones Act?
I mean, I think the answer is yes. It's a featherweight standard for liability, and whatever fringe you've got going on is fine with me. Those cases are really favorable to Jones Act seamen, and I'm curious to see how this COVID case turns out. I would not want to be the defendant, and my brother works offshore, and I would never tell you where he works, but they're a reputable company. But the reality is, a lot of these offshore semi-submersibles, platforms, vessels, drill ships were scrambling during COVID because they have to bring people in and out almost nonstop to stay staffed. And how do you develop quarantine protocols when your staff is constantly in flux and in very close proximity in a room smaller than this on a helicopter? And then you add to that, how do you treat it? I mean, you don't have to look very far down the internet to figure out that there was a pretty significant amount of time where we were at a loss, which is no excuse. When you got to take care of your employees, you got to take care of them.
Injecting chlorine was not available?
I actually have some hydroxychloroquine, which I'm willing to auction off to the highest bidder. We will put that on the website.
Save it.
I've also got, what was the other one? What was the horse stuff?
Ivermectin.
I do in fact have a topical solution with ivermectin in it that I give each of my kids just a little dab every night behind the ears and on the tongue, and they've been COVID free so far.
Yeah, one thing that's actually kind of interesting, the intersection of maritime law and the COVID issue is maritime is where we got the concept of quarantine. It was the 40-day period in which a ship had to stay offshore in order to make sure that we did not import any sort of contagious or infectious disease. So quarantine is deeply tied into maritime and shipboard life.
Absolutely. a son of a gun is a child born between two cannons on a ship. But we digress. In any event, that's a son of a gun of a case, and I'm looking forward to. I'd like to see how that turns out. Maybe Peter, maybe you know some of the lawyers handling that file. Maybe we can get somebody over here to talk. About it.
Yeah, we'll look into that. We'll do our best, and we'll check in. No matter what happens, we will report back on what happens with it.
Fantastic.
All right, let's move on to the next one. All right, Kyle and distinguished guests. The next story I want to talk about is a follow-up to one we've discussed before. As you recall, Kyle, we talked about a man at the Total Wine and More on Holcomb, which apparently you have been to a time or two, alleged that a pallet was left in the aisle, and he fell over it and became very injured.
Okay.
So we discussed that last time, the concept of, just basic premises liability. Got to show there's a condition, and the property owner knew about it and didn't either warn or remedy it, and that caused the plaintiff to be injured.
Wait, is there another Total Wine and More claim?
Yes. Just to follow on that,
you guys at some point, you lawyers, are going to make it so cost prohibitive that I'm not going to be able to get Fireball or Schlitz, and it's going to be a dark day for democracy. That's all I'm saying.
It could happen, and you guys missed this. My son actually worked at Total Wine and More, the one in Austin during COVID, and he's a big fan. Yes,
are big fans.
Yes, we all are big fans. But maybe you have to be careful. I'm not sure. But yeah, we talked about the distinction that on a dangerous condition, the challenges to the plaintiff's lawyer are showing advance notice to the landowner, and also the fact that, well, if it was so dangerous, why didn't the plaintiff see it? The old open and obvious, which I hear when I'm mediating these cases, I hear those positions frequently. Okay, so this next one, there's a second filed against Total Wine and More. This one, though, argues that the plaintiff was stopped at an aisle when an employee stocking shelves on an aisle on the other side pushed a box off the top shelf, fell, and landed on her head. So, esteemed practitioners, I thought that'd be interesting to talk about the concept of in the premises world, premises liability between a dangerous condition and a negligent activity case. How are those different?
I didn't realize there was going to be a test.
You want to pass it to Kelly?
So I've actually had to think about this a couple of times in my career, but I think there's probably smarter people here than me. So why don't you let somebody else chime in, and there's no chance they know less about it than I do.
I'll talk about it because I actually have a case pending in the Supreme Court that deals on a slightly different issue. But the crux of it, what turns negligent activity into a premises case, is whether or not there's contemporaneous activity. Is the landowner doing something at the time? If the landowner did something in the past and the result is the land is dangerous, that's negligent. That's a premises liability claim. If the landowner is doing something at the time and that injures you, that's a negligent activity. Now, what is interesting, and I've had this case, is what if the thing that they're doing makes the land dangerous? And then it comes down to really just a question of how related is the activity to the fall. So in my case, I had a client walking down the aisle at I believe it was a Kroger or H-E-B or grocery store during the stocking. And so they've got a bunch of boxes, and they're unloading the produce, putting it up on the shelves. They're breaking down the boxes, and all the boxes laying on top of other cardboard become slippery, and my guy slips and falls on the cardboard. And we, of course, allege that the negligence was not just leaving the cardboard out, but breaking it down and putting it on the floor, which you were contemporaneously doing. And, of course, their response was, well, no, that had already come to rest. We were working over here. Now, ultimately, we got it settled. So we never got a final answer. It was one of my fun little anecdote settlements. We were $500 apart to get the deal done. And finally, the defendant offered a $500 gift card to the grocery store. And I was like, that's where I shop. So I called the client, said, do you have an issue? And he said, no. I said, great, we'll take it. It's part of my fee.
I'll just add that that was a great explanation. But you also, if you can make a premises case potentially into a negligent activity case, you want to do that because it's easier to prove a negligent activity case than a premises case. Premises case has a lot of defenses, for example, open and obvious, that don't apply in a negligent activity case.
What if you keep wild animals on your premises and they attack someone? Is that someone off the property? Is that any idea? Is that negligent activity? Is that premises liability?
Well, it's not premises liability because you said the magic word, off the property.
But because the gate was broken.
I think actually I've handled I've handled a few dog bite cases, and I think it's just a negligence case. It's a foreseeability thing too. If the dog has bitten somebody already, then you know that you have a dangerous dog, and we've all heard every dog gets one bite, so don't let that dog get out.
So what if you're buying Mad Dog at Total Wine and More? Terrible puns. I'm sad to see Total Wine and More getting all of this bad pub. I feel like I should go out and buy everybody a nice bottle of wine from Total Wine and More to make up for it. Total Wine and More, we would love to have you live. Send a corporate rep with a couple of boxes of booze, and we will make sure that you have a chance to rebut these no doubt spurious claims against your good name.
Who's defending them? Do you know?
No, at this point, likely they haven't answered yet because these were just filed, both these cases. And really, in their defenses, we know, as we see, any store like this will get lots of claims filed against them.
It happens, and sometimes they're great cases, and sometimes they're terrible. And
that's just
each case has got special facts.
That's just the nature of operating a business. There's going to be, no one's perfect, and that's why people have insurance. Okay, so that's. I think we've covered the watershed on that one. We'll keep an eye, as we do, on all these and report back when we know more.
Sounds good.
Thanks for joining us this week at the Dirty Verdict Podcast. For links to some of the stories discussed today, please visit our website, www.dirtyverdict.com. If you have obtained a recent verdict and want us to discuss it, please email details on the verdict to us. Also, please follow us wherever you get your podcasts.